All right, welcome back. So this week we cover two separate chapters, one of which we'll finish covering next week. The first one is Chapter 7. It's on concurrent interests, and we will cover the entirety of the material that we'll cover in this class on concurrent interests in this week. So you'll see it's been abridged somewhat, Chapter 7, from what you had to read, right? We removed the stuff on family property mostly, because it's not directly related to property law per se, and we had to pick eventually, so you didn't have to read the entire 800-page textbook. So again, it's the only thing on concurrent interests. It should be somewhat simpler than certainly the material on estates and land, but also most likely the rest of the material for this term, because it quite significantly builds upon the stuff that we've seen so far during the semester. So, what does a concurrent interest mean, right? So, let's say you have a house, which is obviously property, right? Could very well be personal property as well. It doesn't make a difference. Same principles will apply, subject to all sorts of formalities that we might have seen regarding registration, pursuant to a registration statute, or having stuff in writing pursuant to the statute of frauds. But the principles are the same unless something additional applies for both real and personal property. So, what is a concurrent interest, you ask? Well, it is what it says. It is an interest that is concurrent. It is simultaneous. That's what it means. So if you have a house, right, the traditional conception that we've had so far would be A has the house. So A has a property relationship with the house, right? Again, the nature of a property relationship, reason why we know it's one, is that it's a direct relationship between a person and a thing, as opposed to two people as you have in contract law, tort law, everything else. So the relationship between A and the house is a property relationship, which will be characterized in some way, right? Say it's a fee simple by default. Well, A has fee simple, which is a direct relationship with the house, and in that case, right, the full relationship, the full bundle of rights, as we have discussed. You'll recall we said there's all sorts of things you can do with that, and we've seen them so far, right? So say it's a fee simple, you can dismantle it, that's what we said. So you can give someone a life estate, which is a present interest to possession, or a lease, which is also a present interest to possession. And you retain, right, reversion, remainder, whatever it is, which is a present interest to future possession. In that, you have dismantled the right that you had, which was a fee simple. You've dismantled it into two parts, one of which you kept, and therefore there is a present interest to possession, which you no longer have, and there is a present interest to future possession, which you retain, and when you combine the two, right, it is the fee simple that you started with. We said there's other things you can do with your fee simple, your bundle of rights, your property interest. Again, could be a subset of that, right? You can also do whatever you want with it. That's the nature of a property interest. You can sell it, transfer it, all that, right? Same thing if it's a life estate, for example. So, we also said you can have conditions on an interest. It's another way in which you can change it. So you can have a condition precedent, a condition subsequent, right? A feasible, determinable, all the stuff we talked about. And you'll recall we said you can transfer it. That's the nature of a property interest, and you can transfer it all sorts of ways. You can transfer it for free or for money. There's no requirements that it has to be for money, although, as we just saw, right, if it's for free, you might have to go to the registry to register it, right? Or have different criteria that will apply as to, sorry, I'm stating myself, on the validity of the transfer. So additional requirements that you have for gift, for example. Nonetheless, right, there are legal requirements as to how you do it. Doesn't change the fact that you can. So got a property interest, you can transfer it for free or for money, and when you're alive or when you die. So a divisory bequest. We saw that as well. Another thing you can do is hold it concurrently with someone else. And so you can have a fee simple, right? Which is a property relationship. And actually you might conceive the three lines as being the same one, right? The same fee simples. For example, you buy a house with your wife. That is, an interest that is concurrent. You share the fee simple in the house. And so instead of the traditional permutation that we saw, you now have two people who hold a property interest of the same nature, the same one in fact. That's a concurrent interest. So if you have A, B, and C hold title in the house, that is a concurrent interest. So it's concurrent meaning simultaneous. They all have it at the same time, right? And that is different from the two things that we discussed, and which you have in the book at page 556 and 57. So first, it differs from a successive interest. So my example with the life estate, you have a present interest of future possession, which is the life estate. And then you have a present interest of present possession, which is life estate. I'm not sure if I misspoke. Present interest of present possession. You have a present interest of future possession, which is a reversionary interest. So that is successive in that. Possession is successive. Someone has possession now. You have possession later. It's a successive interest to possession. Both of them are present, right? For all the reasons we saw, I won't repeat that. But the two interests are, right, possession is successive. Different from concurrent, because it's not simultaneous, right? Simultaneous would be both people have a right to possession at the same time. It's also different from a shared interest, which is when you have, right, the same thing happen. You have two people who hold an interest of a certain nature at the same time, but it's not the same interest. As we'll see, that's one of the requirements. So if you have a bailment, right, which again is a property interest. So the person you lend your stuff to, again, right, for free, for money, personal real property, whatever it is, right, the person you lend your stuff to has a property interest in a bailment, not a license. If it's a license, then, right, it's not a property interest, and the trouble comes in. So bailment get a property interest, you retain a property interest because you have not renounced your title, right? That's what we said. It's different from, say, a lost object, because you give someone your stuff with a specific provision and therefore intent that they will only have it for a set period of time. So shared interest, but not concurrent because it's not the same. So in my example, A, B, and C share the title in the house. They have the same interest, which is a fee simple, and that interest, right, entitles them to present possession. Because if you have fee simple, you have a right to possession. That's the definition of the right of the rights, right? The definition of a fee simple. If you've got two people now who have a fee simple, they both have a right to possession. It doesn't start, right, having to be shared 1 week out of two. Doesn't work that way. So you have the same right, so you have the same right to possession in the house. In contrast, in a bailment, it is an interest of a different nature. The interest of the person who takes your stuff pursuant to a bailment is different from your interest you retain, which is a fee simple, right, subject to a temporary lending of your stuff to someone else. It's shared. Distinction between shared and successive being, of course, that it's at the same time, unlike, right, successive interest to possession is in my example. But it's different from concurrent in that it's not the same interest. So, right, concurrent means, and we'll see it's actually a bit more complicated than that, but it means the same interest, right? So, for example, a fee simple, and at the same time. As we'll see, right, there are the four unities, blah, 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 which makes this a bit more complicated because there's actually four things. But These two criteria, which are out of the four, of course, are helpful in helping you delineate the difference between the three types of interests that we just mentioned. Okay, so historically you had, that was something that you wanted to avoid as much as possible. Namely because it meant that you had more people who had feudal dues, right? So you'll recall there used to be this very elaborate system whereby, right, you never actually owned something. The king actually owned it, and then they gave you a right to it, and then you had someone as an intermediate who we called the feudal lord, who was just sitting on their butt, and then the king put them there because they liked them, and they collected money for that. So it was not something people liked, and so you wanted to reduce the number of times that you had people holding concurrent interests. So you wanted to limit the number of people who were subject to feudal dues. And that is why there was a presumption in favor of, right, a joint tenancy. And we'll see what that means, right? And now I'm at page 558, right? So there was a presumption in favor of a joint tenancy at common law, as opposed to a tenancy in common. So you actually have 4 types of concurrent interests, which are enumerated around that page, right? But the last 2 are, for our purposes, not relevant because they don't exist anymore. So a tenancy by the entirety of an A-Copar tenancy, not important. So for all intents and purposes, you've got 2 types of concurrent interests relevant today. It is the joint tenancy and the tenancy in common. The joint tenancy has the right of survivorship. That's the salient difference with the tenancy in common. So what's that mean, right? If you've got A, B, and C. So same thing in both, right? Because they are both concurrent interests. So they both meet the definition there, the joint. So A, B, and C have an interest in the house, which is present, shared, right? All the stuff we said. Now, the distinction happens when someone dies. So A dies, very unfortunate, right? Then what happens? Well, A's interest, A's concurrent interest, is not passed to their heirs in a joint tenancy. Instead, it is extinguished. And sometimes people say it passes to B and C, but that's actually incorrect, conceptually. Because everyone has a right to the whole. You'll recall I said you have a right to full possession even if you have a third or a half of the thing. That's why. So A's interest is conceptually extinguished, and therefore B and C now have the same interest, A fee simple, but in a greater proportion. And again, not because it was transferred to them, but because A's interest was extinguished, right? There's 100%. It's split into 3, that's a third. Then you have one of the third disappears. Well, now you've got half and half, right? Hopefully that makes sense. So, essentially the rights of the surviving owners increases, and the corollary of that is that a joint tenancy does not give rise to an interest that you can transfer by will or by dying in intestacy. That's the distinction. A tenancy in common is the opposite. So again, meets all the criteria, hence why it's a concurrent interest, but it's different in that it does not happen. So A has a third. If they die, they give it to whoever they want. If there's no will, it's intestacy, right? So the law that says who gets your stuff when you die if you have no will. It's what we call intestacy. And as we said, right, pursuant to all the principles we talked about, it eventually goes to the crown, right, because of its inherent title, essentially, right? But the government tries very hard to find people to give it to before it takes it. So, right, A dies, it goes to their heirs or to whoever the law says is their intestate heir. That is the distinction. At common law, you had a presumption in favor of a joint tenancy. And that's because, as I said, people did not like to owe feudal dues. And as you can imagine, if you have a mechanism by which, when you die, you lose your rights, well, of course, it's good, because it reduces the people who owe feudal dues. Because if you have a tenancy in common, you've got A, B, and C, right? A dies, gives it to their heirs, D, whoever it is. Well, now you still got 3. Joint tenancy, in contrast, A dies, now you've got 2. It's good. Fewer people owe dues. So that's why you had the traditional common law presumption, which we'll see was reversed. So, to the extent that you had a grant, which was just jointly, didn't properly, clearly evidence an intent for it to be something else, namely a tenancy in common, the presumption applied, and it was a joint tenancy. Okay, so you have a case on that, right? The McEwen case, which is very old, right? 1946. Nonetheless, it invokes a statute. And that statute says what I said. So I said there is the presumption, has been reversed. The presumption that the interest that you've given is a joint tenancy, which is the presumption in common law for the reasons I mentioned. That presumption has been reversed by a statute. Obviously, it's not the same now, but cited at page 559, which now says the opposite. Now it's a tenancy in common. So it is, right? So statute says that. Therefore, now, if it's not clear, we will favor the interpretation as a tenancy in common, and therefore there being no right of survivorship, and as a corollary of that, an ability of the person who owns the right to transfer it by will or through intestacy. So that's what you have there, right? You have language which is somewhat equivocal. It says, someone gives someone property, right? The specifics don't really matter. Jointly, and should they decide to sell said property, each of them is to have an equal share of the proceeds of the sale. That's equivocal. It might have said something that clearly suggested a tenancy in common. For example, it might have said, if they die, they will give it to their heirs. Well, now you're saying something which is inherently incompatible with a joint tenancy. So, in common law, although there is a presumption in favor of a joint tenancy, it would have been rebutted because you showed sufficient intent, namely by saying something which is inherently, right, incompatible with a presumption. All what you have there, it says if you sell it, don't get the money. So, it's not clear, right? And essentially, the presumption applies, and as we said, the presumption's been reversed, right? So, the new presumption here is that there's a tenancy in common. To the extent it is not clear, right? It is now a tenancy in common. And again, now you have to show same thing. Presumption can be rebutted. That's the nature of it. Now you have to show a sufficient intent, but to the opposite effect. You have to show a sufficient intent to create a joint tenancy. So, ostensibly, that would mean that you say something about, right, people dying and what happens when people die, and that would be the definition of a joint tenancy, right? So you would say, if they die, they will not pass it to their heirs. Now it's a joint tenancy. You could say, if they die, right, it will accrue to the other owners. Same thing. And you have an interesting point, right, at the middle of the page, that the word jointly in itself does not suggest a joint tenancy. Jointly just means, and that's kind of significant, right, because the word joint is only in one of the two, right? Tenancy in common doesn't have the word joint in it. That word in itself does not sufficiently evidence an intent that rebuts the presumption. Essentially, joint we assume to be used in the traditional, ordinary usual way, which is to mean concurrent, which just means share, which means at the same time and the same interest. Okay, and you have something which isn't mentioned specifically, right? But the presumption is pretty strong. So because it is very unlikely today, right, by default, you'll assume that people will want to give people stuff, and they assume that when it's given, right? If you give it to 3 people, your assumption is it's the same thing as if you gave it to 1, and if you give it to 1, when they die, they do whatever they want with it. So there's a strong assumption there that today, people will, by default, very, very likely want to create a tenancy in common. Whatever words they use, right, imprudently. So it's generally seems to be a strong presumption by virtue of the case law that you have to have a very clear intention or very clear language to rebut. Okay, 560, you have the stuff I said on accruing, right, saying it's not accurate to say it was transferred when someone dies because of the right of survivorship. Okay, and the law is mentioned at page 561, right? The Conveyancing and Lawyer Property Act, which is newer than the one that's mentioned in the case, but of course is the same thing. And it establishes a date, which is kind of important. That's 1834, right? For all intents and purposes, you know, cases about stuff that happened before that date don't get litigated all that much today, right? Nonetheless, the presumption only applies to cases after that date. So, same thing as you had with the life estate, right? You'll recall that if you gave something to someone, you just say, I give to A. Well, at common law, the presumption was it was a life estate. So by default, you were assumed to have given A life estate, not a fee simple. And that was because, of course, right, the feudal lords, again, which always wanted their stuff. So that was the assumption. So if you did not say to A for life, didn't matter. It was a life estate unless you evidenced a sufficient intent to the contrary. And you'll recall a law was passed in Ontario to rebut that, and you'll recall there was a magic date. It said, if it's before that date, the presumption does not apply. Same thing here. You've got a law which was passed, which reverses a traditional common law presumption, right? Ostensibly because it's based on completely outdated perceptions of the nature of property. And there's a magic date, so it has to be after that date, otherwise does not apply. And as we'll see, there are additional exceptions, page 562, which don't really matter, but you should still know them. So it does not apply to people who are, again, granted something, right, concurrent, joint, as executors or trustees. So the presumption is limited, applies to everything else, every other transfer of property. Again, it could be by will or otherwise, right? It could be by deed or otherwise, sorry. It does not, though, apply to people in their capacity as executors and trustees. You know what that means, right? Executors means the executor of a will. So when you die, you'll name someone to do the stuff. So you can't do it yourself. You're dead, right? If you say, I want my house to go to my wife, right? It doesn't happen magically, of course. And you can't do it yourself because you're dead. There's no government agent to do it for you. So you name someone who's the executor of your will, who will call up a lawyer and say, well, now we've got to effect this because it's written down on the piece of paper. That person is the executor. If you don't name them, the law will, and usually that person won't be very happy because it's a lot of work. That's an executor. A trustee is what you know. A trustee is in a trust, right? Is someone who holds property on behalf of someone else pursuant to a trust structure, which I think we've covered sufficiently already. So Does not apply in these specific circumstances. So, what's that mean? Traditional common law presumption applies, and you have a joint tenancy instead. Otherwise, it applies, and as I said, good to know, but very unlikely that you'll have a case where that specific exception applies. Okay, two things that were added by statute as well. First, when you have, and again, right, it's somewhat unlikely that you'll encounter that, but you know, you're still supposed to become a lawyer. So, first is if you have simultaneous deaths. Second is if you have a corporation. So, if people die simultaneously, then it's trouble, right? Because now you've got A, B, and C. Now, they get into a car accident and they're all dead. What happens, right? You're kind of screwed because if you eliminate all the three, now there's no one to hold the 100%. And it also hasn't passed by will because it can't. That's the whole point of a joint tenancy and the conceptual structure we saw. So, simultaneous death in a joint tenancy, what happens, the law, some statute, not the Conveyancing Property Act, another one, says, which you don't have to know, says, if you die simultaneously, it's as though it were a tenancy in common. So, we will act as though it were a tenancy in common. What's that mean concretely? There's no survivorship, there's no accrual of the right, there's no one who gets more. And it passes, which otherwise we said it can't, right? It passes to whoever is provided for by will or intestacy as though it had been a tenancy in common. Second thing, a corporation historically could not hold a joint tenancy, could hold a tenancy in common, of course, right? You can have your house owned by a corporation or two or three or four, right? You could not have a joint tenancy because the nature of corporations is that they don't usually die, and significantly they don't have to die. Unlike a human being. A human being can live forever. It cannot live forever. A corporation can. Sometimes won't, right? Might run out of money, might do something bad, but if it doesn't, it can live forever. That's the underlying rationale. That was also reversed by statute, and now there's a statute that says you can have a joint tenancy with a corporation. And so, there will be survivorship, and death will mean what we would, assume it to mean, and that is, right, a company dissolving or stopping to exist in some other ways. Okay, we'll do some erasing now. So, another distinction that you have for a joint tenancy only, of course, is what you have there. Okay, so if you have a joint tenancy, you'll recall a joint tenancy being the thing that has the right of survivorship, and that's what makes it different. So, you also have to have, namely it's part of the definition of a joint tenancy, 4 unities, right, which is a very elegant way to put it. So 4 things that have to be the same for all the people. So A, B, and C in my earlier example own the house. Well, if it's a joint tenancy, they each have to have an interest that matches 4 characteristics: possession, interest, time, and title. So, Possession means what I said. They have access to full possession, not a third, full possession. They can show up, occupy the house as though they owned 100%. Subject to the others, of course, who can do the same things. If you don't like them, they can still show up while you're there because they have the same right as you do. Interest means they have an interest of the same nature. For our purposes, we'll assume it means it has to be the same size. Lots of discussion on that. For our purposes, same size. So you can have a third if you've got 3 people. You can't have a third if you've got 2 people. Now they don't have an equal share. Doesn't count. Time means they acquire the interest at the same time. So if it's by a contract, it's by a contract or a will, whatever it is, right? But they can't acquire it later and separately. Doesn't work. And it has to be for the same period, which it won't be because it's the same interest, right? Title means you acquire it by virtue of the same instrument again, right? So if it's a contract, it's a contract. You have to acquire it by virtue of the same instrument. So if it were, say, at the same time, but not by virtue of the same instrument, for example, a contract, it wouldn't count. Okay, and another example, by the way, of time might be, so the correlate, the opposite of what I said. So you can have title, same document, but the document might say it starts later. So it would be created by the same document, but not at the same time because it would be deferred to the future. That's an example where, right, because otherwise time and title often are conflated and extremely similar. Because they both refer essentially to the granting document. Okay, as is mentioned there, you've also got 2 other types of tenancies. So it's not all. You also have, right, the tenancy by the entireties and the co-part tenancies. It's not just a joint tenancy and tenancy in common as we said, but it kind of is because you can't create the other 2 today. So we'll talk about them briefly, but you don't have to know them. Tenancy by the entireties was when essentially wives did not exist. So when people got married, the wife did not have legal personality, right? Legal personhood, therefore could not hold stuff on their own behalf. For example, a house, it just didn't work. Couldn't have it in their name because they didn't have a name under which they could hold title. It was the husband, and therefore, right, you had a different type of tenancy when the husband held something like a house for the family. It's a tenancy by the entireties. Then you have a co-part tenancy, which was essentially to avoid, and you have the whole explanation there, which we won't get into because it will take very long, but essentially to avoid women being able to own property back in the days. Okay. Other important issue which is covered in this chapter is severance. So, you essentially have, and this is actually a bit more complicated than that, you essentially have a right to not be in a joint tenancy. So to not have the right of survivorship applied. And when you do that, right, you'll do that by essentially engaging in an action that is inconsistent with that. So if you try to destroy one of those, so you transfer your thing to someone else, for example, well, now you don't have time and title. So it's no longer a joint tenancy because it requires the 4 unities. As we said, it's the conceptual definition of a joint tenancy. So it has to be, it's part of the definition. It has to be there. So, right, you're screwed because you don't have the 4, and therefore it's no longer a joint tenancy. Therefore, you no longer have the right of survivorship, which is the distinctive aspect of a joint tenancy, of course, and therefore it becomes a tenancy in common. And you can do that by an action that's inconsistent with it, and generally you can do that unilaterally. Namely, right, you don't have to ask for permission of the other people who are involved. Okay, and you have a case there, or an article which says essentially what I said, right? So you can have it done mutually, right? So because you can do it yourself, of course, you can also have everyone agree. It's even better, right? So if you have all three, say, in my earlier example, A, B, and C, they sit together, they agree, we don't want the death thing to apply, you can have it. They can mutually sever a joint tenancy, namely destroy it, one of the four unities, or more than one of the four, therefore becomes a tenancy in common, therefore, right, the consequence of that is that the right of survivorship does not apply. And you can do it mutually implicitly as well, so you can have a mutual course of action that's inconsistent with a joint tenancy that will also sever it, or you can have, right, that done unilaterally by an action that is inconsistent with it. Okay, page 568, you're mentioned essentially it has to be unequivocal and it has to be complete. So for example, if you grant a mortgage on your thing, that's a property interest, but it doesn't necessarily, right, destroy your thing because you've kept an interest of a similar nature, time and title, therefore it's equivocal. So it's not clear if the property interest is inconsistent with, right, the four unities that you have. Okay, page 570. Okay, page 570 is quite significantly, if you do it unilaterally, it does not necessarily sever the whole tenancy. So, it might sever it for you, right? Of course, you're no longer subject to right of survivorship for your third, but it might create a tenancy in common for your third. And the other people might remain in a joint tenancy and therefore subject to the right of survivorship. Okay, as you mentioned, page 573, not all that important, right? Often there are additional statutes that will apply and will limit your ability to do things unilaterally, which otherwise you have the power to, oftentimes in the family law context. So when you have, generally these married spouses, right, there will be additional requirements, which there can be, right? You've got the common law by default, but the government can always supersede that with a statute, a law. This is otherwise. So, do that in the family law context. Have a law that says, for example, you cannot remove the right of survivorship from your wife without their consent. And we won't get into the specifics of that. Okay, then 574, you have a section on rights and obligations, which essentially boils down to what we call occupation rents. So, by default, as we said, you have, one of the things that you have is a right to possession. That's the nature of a concurrent interest, regardless of whether it's a joint tenancy or a tenancy in common. We said that. You have a right to full possession, as do the other people, right? But you have a right to full possession, not a third of possession. That means that people cannot interfere with it. Of course, if you decide not to exercise possession, that's fine, right? Doesn't mean that someone violated your rights. If you decide not to exercise possession, it's your problem. You're still a third owner, you'll still have to pay a third of the expenses. Now, if someone prevents you from exercising your rights, so they change the locks on the house, well then they will owe you occupation rent. So they have interfered with your right as a concurrent owner, namely your right to possession, by not letting you have possession. Again, it being different from you choosing not to exercise your right to possession. Now, they've prevented you from doing that, right, without your consent. And therefore, they will owe you what we call occupation rent. They'll have to pay you for the value of the right that you lost. So ostensibly would be whatever the house can be leased out for divided by 3. It would be what you're owed. Then you have people who are responsible for the expense, again, to the extent that there's no trouble going on, right? So if you overpay more than your third, then you'll have to be accountable for that, right? And you can seek refund from the other people. Okay, another thing you can do, which is separate from severance. So severance, we said, pretty simple. You can do that unilaterally, and severance, of course, in the specific context of a joint tenancy. Otherwise, there's no severance to be had, right? Because the point of severance is it severs one of the unities, therefore removes the right of survivorship, therefore transforms a joint tenancy into a tenancy in common. That's the nature of severance, can be done unilaterally. The other thing you can do is petition. You can just say, well, I don't want to be a co-owner anymore. And that would be true in a tenancy in common as well. So you own a third of the house, but now you say, I don't want to own a third of the house anymore because I'm sick of the other 2 people. That you don't have a right to do by default, right? Of course, if you own the house, you can sell the house. Well, if you own a third of the house, well, you can't sell, right, without the consent of the other people, or potentially you could, right? But if you wanted to get away from owning just a third, for example, then, right, you couldn't do that without the consent of the other people. You'd have to ask for what we call an action in petition, and that is to force the court to split it. So, and petition means that, right? So it means, for example, you've got the house, now you have a third. It means you have not a third of possession, full possession with the other people. Now you're sick of living with the other people, right? Partition would mean we want the house to be split into 3 physically. Therefore, you won't have to encounter the other people. That's partition. So you separate a shared property. If that doesn't work, you could ask for the sale to be forced. And that's another way, of course, not to be in a in a concurrently held interest anymore. Okay, and the law, right, so there's an act on that in Ontario, and it says, and that's significant, it says, other people may be compelled into an action in petition or sale. So the other 2 people, even if they don't agree, if they agreed, it wouldn't be a problem. You wouldn't have to go to court, you wouldn't have to have a law apply. So the other people don't agree, law says they can be forced to suffer petition or sale. It doesn't say they must be forced. It doesn't say as soon as you ask for it, you get it. It says you can ask for it, and that's the rule, right? So you can ask for it, but you won't necessarily get it because you have a right. Again, the right is a right to ask for it, not the right to get it. And the court will decide, right, you've got a case on that, not that important, but the court will decide whether it's a petition or sale. Usually will favor a petition. So to the extent that it's possible, oftentimes won't be, right? Not all that simple. If it's a house, you can split it physically into 3 portions. Lots of other things you can. So in actuality, oftentimes will be a sale, but first the court has discretion, and second, usually the court will favor petition. Okay, and you have 2 cases there. Which will essentially say the same thing. So, Katel and Gerfella, both of which say essentially that there's a presumption again, that you can get it. So, as we said, the law itself says you can ask for it, doesn't say you get it. But the cases, right, the 2 cases that you have will say presumptively you can get it when you ask for it. So presumptively, if you ask for it, the court will order it, and the person who opposes it will have to justify that. So essentially it operates a presumption. So instead of you having to establish why it is that you want it sold, which would be the default thing, right? It's how it works in court. You have what we call a burden of proof, which means you have to adduce sufficient evidence to get what you're asking for. Now it's reversed. So you ask for it, by default you get it. If someone disagrees, now that someone has the burden of proof. That's a presumption. Presumption reverses the burden of proof onto the defendant. So you're suing your two co-owners, they say no. Now the burden is shifted onto the two people, the defendants, and now they have the burden. So by default you ask for it, you get it, unless they meet their burden to show why it should not happen. That's what the case is saying. Okay, then you have a discussion of condo law. You know, we had to cut somewhere, very interesting, but we had to cut somewhere, so condo law is very specific, very helpful in that it helps do things that we think are favorable, namely pile people up in a city, which otherwise would prevent all the lovely things that we have with globalization and industrialization, because, right, cities would be too big. Now we want to pile people up. That's what condo law is for. So increase urban density and lots of other things. Well, first, condo law is, right, subject to a separate regime. So you'll have in Ontario the Condominium Act, which will subject that to a specific regime. So you've got default rules. Well, now you've got additional rules, or rules that reverse the traditional rules. Again, that's what legislation is for. Changes the common law. And, right, therefore you're subject to a specific regime. But by default, it's the same thing. So if you have your unit, of course, it's fee simple. So the physical portion of the building where you live, of course, that's a fee simple. Because if it were a concurrent interest, even though you've got 100 people in the building, if it were a concurrent interest, it would mean that the 100 people could show up in your condo. That would be a problem. Therefore, it's not what you have. So you have a fee simple in your portion, but the shared areas are concurrently held interests. So a tenancy in common. That's why you can use the hallways, and that's why everyone else can use the hallways. Otherwise, right, either or would be a problem. So it's the same thing. Right? It starts with all the arcane stuff that we saw. It starts with property law, common law property law, starts with the feudal lords, and that's a structure that you have still today for how you hold a building, or a portion of a building, in that example, like a hallway, concurrently with other people. And therefore, right, it's a tenancy in common, and you'll have additional rules, right? You'll have what we call condo bylaws, which will have all sorts of rules, additional rules, which will say, right, you can't get your dog to pee in the hallway, which is something that you otherwise would have a right to do. Okay, so as I said, we're splitting lots of that. There's a discussion of family property at pages 590 to 592. Again, not something we look at in detail. I think the 3 pages you have give you a pretty interesting overview, which I'm sure will lead you to read the rest of the chapter in the summer, if you're very disappointed that we're not talking about it today. But all that, right, based on traditional gender relations and coverture, which is, right, a relic in the law when women can hold stuff for themselves, but nonetheless still has a significant impact because, right, the various tenancies that we saw were designed specifically for that purpose. So we'll stop there for chapter 7 and be back for chapter 8, which we'll cover the beginning of for this week.